The general and specific intent crimes are easy to memorize. First, we're going to cover mistake of fact and mistake of law as a defense. A mistake of fact negates the mens rea for that specific crime. What does that mean? What is a mistake of fact? A mistake of fact would be, say, when the defendant kills the victim by poison, but he honestly believes he's administering medicine. He's made a mistake of fact regarding whether something is a crime. A mistake of fact is a mistake where you believe you are not committing, that fact does not constitute a crime. You thought you were giving them Tylenol, instead you gave them cyanide. That is a mistake of fact. What is a mistake of law? Okay, a mistake of law is three things. One, it negates criminal intent. In other words, somebody's accused of robbery, but actually they're operating under a mistaken belief that the money is owed to them. Or the law is underpublished. This is called the fair notice exception. The accused did not have fair notice of the law. Or they just have the fair notice exception also covers an incorrect official interpretation of the law. So a mistake of law negates the specific criminal intent. You are a landlord. You mistakenly believe that the law allows self-help eviction. That's a mistake of law. Or there is the fair notice exception. The law is underpublished, or there's an incorrect official interpretation of the law. You didn't have fair notice of the law. All right, now that we've covered that, let's memorize the general and the specific intent crimes. The general intent crimes, you just have the intent to do the crime. You have no intent as to the person or the result. And I have dogs. So the mnemonic device is abarkif, A-B-A-R-K-I-F, abarkif, abarkif. That is our mnemonic device. A for assault, B for battery, A for arson, R for rape, K for kidnapping, I for involuntary manslaughter, and F for false imprisonment. Abark, if. A for arson, B for battery, A for assault, R for rape, K for kidnapping, I for involuntary manslaughter, and F for false imprisonment. Abark, if. Okay, so the general intent crimes, a mistake of fact is a defense. Okay, let's just use a quick example of assault and battery. You are a doctor. You believe you've obtained informed consent. But somebody else signed for the patient. There's a mistake of fact. Okay, so mistake of fact is a defense to general intent crimes. I repeat, a mistake of fact is a defense to general intent crimes. And what are they? Abark, if. Assault, battery, arson, rape, kidnapping, involuntary manslaughter, and false imprisonment. Mistake of fact is a defense. Abark, if. Specific intent crimes. Here's where we have the intent to do the crime and the defendant desires the specific result. So you defendant must possess the specific intent to do it and the specific intent for the result, or you are, that's right, not guilty. You have to possess the specific intent to do that crime on that specific person with that specific result, or you are not guilty. Therefore, do you think mistake of fact is a defense? No, mistake of fact is not a defense. Why? Because you desire the specific result. Okay, so sometimes people remember these by Marla C. Beth. M for murder, A for assault, R for robbery, L for larceny, A for attempt, C for conspiracy, S for solicitation, B for burglary, E for embezzlement, F for forgery, and F for false imprisonment. I don't really like to do it that way. I break them into three categories: the three crimes of violence, the three inchoate offenses, and the four theft crimes. So the three crimes of violence are murder, robbery, and burglary. The three inchoate offenses are attempt, conspiracy, and solicitation. And the four theft crimes are embezzlement, larceny, forgery, and false pretenses. Okay. Violence, murder, robbery, burglary. The inchoate offenses, you know them: attempt, conspiracy, and solicitation. And the four theft crimes: embezzlement, larceny, forgery, and false pretenses. Is mistake of fact a defense to these specific intent crimes? No. No. Okay, what if we get a negligence crime, like negligent homicide? This is our one exception. A reasonable mistake means that the accused didn't act negligently. They're not guilty because they're not negligent. If you're not negligent, you can't be convicted of negligent homicide. So a reasonable mistake of fact or law means they're not guilty. Okay, specific intent crimes. You have the intent to, that's right, do the crime, and you desire the specific result. And you have to possess the specific intent or you are not guilty. So therefore, mistake of fact is not a defense. Unless what? That's right, it negates the mens rea. Murder, robbery, burglary, attempt, conspiracy, solicitation, embezzlement, larceny, forgery, and false pretense. Mistake of fact is not a defense unless it negates the mens rea. You don't have the mens rea for murder, you aren't guilty of murder. You don't have the mens rea for embezzlement, you're not guilty of embezzlement. You didn't have the intent to permanently deprive, you didn't have the intent to steal, you're not guilty of larceny. Mistake of fact is not a defense unless it negates the mens rea. Okay, that is it for our general and specific intent crimes.